Hello, welcome to the Legal Lineup. I'm Anthony Zaller, an employment law attorney here in California who's been defending employers for over 20 years. Today, I want to discuss some critical issues impacting the service industry and hospitality industry, including tips, mandatory tip pools, service charges, and a growing national movement to eliminate federal taxes on tips. These topics affect employees and employers alike, so let's break it down. First, who owns a tip? Under California law, tips left voluntarily by customers belong solely to the employee. Employers cannot take, withhold, or deduct any portion of those tips. Labor Code Section 351 makes it clear tips are 100% property of the employees. Second, is an employer tip mandated pooling policy legal? California law permits tip pooling as long as it's fair and reasonable. For example, courts have approved policies like allocating 80% of tips to servers, 15% to busboys, and 5% to bartenders. However, policies that excessively favor one group, like giving 90% of the tips to hostesses, have been disapproved. So keep your policies balanced and well documented to stay compliant. In addition, employees in the chain of service, such as servers, bartenders, and kitchen staff, can participate in the pool. However, owners, managers, and supervisors cannot generally be included in a mandated tip pool to comply with California law. Third, do tips impact minimum wage or overtime calculations? So no, in California, tips cannot be counted towards minimum wage, nor do they affect overtime pay. Credit card tips must be paid out no later than the next payday, and employers cannot deduct credit card processing fees from these tips. Fourth, are mandatory service charges the same as tips? No, tips are voluntary and belong to the employee, while employer-mandated service charges are the employer's property. However, any service charges distributed to the employees must be included when calculating the regular rate of pay for overtime purposes. Now, let's dive into the No Tax on Tip movement, a national initiative we strongly support. The idea of eliminating federal taxes on tips has gained bipartisan support. Leaders like Trump, Harris, and Biden have all expressed backing this type of initiative, recognizing the financial burden federal taxes place on tipped workers. In fact, tips were not taxed in the U.S. until 1982. Under the Tax Equity and Financial Responsibility Act is when they became taxed. Before this, they were considered a form of tax-free gift. Senators Ted Cruz and Rick Scott recently introduced the No Tax on Tips Act in January 2025, which would exempt all tips, whether paid in cash, on credit cards, or by check, from federal income tax. This bill aims to provide immediate financial relief to millions of service industry workers. Why does this matter? Eliminating federal taxes on tips and overtime would increase take-home pay for employees, boost job satisfaction and retention in the hospitality industries, help restaurant operators reduce turnover costs and attract skilled workers. This initiative has broad bipartisan support, but it's up to us to ensure Congress takes action. That's why Zaller Law Group has partnered with Tip House to advocate for this legislation. Join us in supporting this movement by signing the petition to eliminate federal taxes on tips and overtime pay. Together, we can help millions of workers keep what they earn and strengthen the hospitality industry and foster economic growth nationwide. Click the link in the description below to sign the petition today. Thanks for watching. If you found this information helpful, please share it with others, and I hope you can sign the petition. For more updates on California employment law, be sure to subscribe and feel free to leave any questions in the comments below. See you next time.